This is entry number 7, and it's dated Monday, March 2nd, 1964, runs 1 page. What can you tell me about entry 7?
Well, I think this is a further evidence of the procedures and we were developing in order to conduct depositions in Dallas. An agreement had been made with the state authorities that no one representing the commission would come during the Ruby trial, and no policeman would be called before the commission until the conclusion of that trial. The internal debate reflected on this entry revolves around the question whether the lawyers from the commission seeking to depose a witness should interview the witness before they put the witness under oath and before a professional recorder. It needs to be emphasized from time to time that witnesses who give testimonies to the FBI do so voluntarily. There's no official recorder around, and they don't have to take an oath. And as a rule, therefore, they're not subject to charges of perjury. But when depositions are taken, they are placed under oath. The testimony is recorded by a certified court reporter, and the resulting transcript, subject to review for accuracy, is an important contribution to a trial until the person is called to be at trial. Here, the depositions were going to be the final product, and the question was whether the interviewing lawyer should take these pre-deposition interviews. It was a sort of an internal matter with some, including Norman, arguing that the pre-deposition interview should not be taken because it might influence or condition the testimony that would actually and be given under oath. Then there were those who said that, you know, pre-deposition or trial transcript interviews are normal, needed. They make the transcript and the actual deposition more logically oriented and more effective. And in the course of that argument, I took the position with those saying that such interviews should be permitted. And one of the arguments I and others could make was that all these interviewers had in fact been interviewed by the FBI or another agency if once or more. So whatever conditioning is to be feared has already occurred. Mm-hmm. So the lawyers ought to do what they feel free to do, and if having an interview before a deposition served their purposes, that was fine, but otherwise they should go in to take the deposition directly. So that's eventually it was resolved in favor of those who said that there was no requirement for a pre-deposition interviews, but if the lawyers wanted to conduct such interviews, that was fine. Mm-hmm. The Chief Justice finally reached judgment on that, and I think largely because of input from Joe Ball, who felt rather strongly that the lawyers ought to be permitted to do what they thought was appropriate.
Right. I was fascinated by that, and I think I told you, I look at it the way I look on oral histories, and in the field of oral history, there's an argument of whether you do a pre-interview prior to an oral history or not. I thought that was kind of an interesting parallel. One quick question before we move on to the next entry. Was there ever any concern, because Jack Ruby was standing trial in the state of Texas for the murder of Oswald, to have the Warren Commission investigate the murder of Oswald by Ruby?
Yes, there was. It's interesting that you raise that, because in fact the Hubert Griffin duo did in fact question, not once but more than once, of whether the commission should be pursuing this investigation of Ruby under the circumstances. The Chief Justice and the members of the commission had no reticence whatsoever about proceeding. And it came to a question, of course, when the decision was made to interview Ruby, and Ruby's lawyers were basically opposed to any interview of their client whose mental competence was still being analyzed in light of the potential for an appeal, which would review the legitimacy of his conviction in light of his mental incompetence. So that may seem hard-hearted on the part of the commission, and certainly, but the Chief Justice took the leadership, as we'll come to develop and read in the journal. He went down initially on a Sunday with our inspector, not someone from the Ruby area, to conduct an interview, and then subsequently that led to a polygraph examination several weeks later, about which there's a good deal to be said.
Right, we'll come to that. All right, very good.